Buckle up, folks. Today's hearing is a masterclass in how not to behave in court. We've got self-representation gone wrong, repeated interruptions, and a judge whose patience is hanging by a single thread. Let's dive in.
The notes reflect that you had previously found count 1 true. She entered a plea of true to count 3, and you've been hearing evidence on counts 2 and 6.
Okay. On allegation 1, failing to report to the probation office in June and August and September 23, did the defendant admit to that, or was that?
You found that previously true back on December 18th of 23. That's what resulted in her being placed on the caseload that this probation officer is on, the mental health caseload.
Okay. We resolved that.
Yes, sir.
All right. Then there was number 2, failing to work faithfully at suitable employment, failing to provide verification of performing community service hours as required.
She pled true to count 3, Judge, by my notes.
When was that?
That was July 21st.
It was several years ago.
No.
Several years
No,
ago.
last appearance.
I'm sorry. No, you're correct. I'm sorry. I apologize.
She entered a plea of not true.
Several minutes ago.
Yes, sir.
She entered a plea of not true by my notes to counts 2 and count 6.
Okay.
I don't have a reference as to anything regarding the anger management program.
Let's talk about that. Number 4, allegation, and we're picking this up on the second amended motion to revoke unadjudicated probation. The defendant, Brittany Cherie Sylvester, is present with her attorney, Mr. Grove, and the state's attorney here in cause number 21-38966. And again, the court has earlier found allegation 1 to be true back in December of 2023, failing to report, but we handled that proceeding, and I held the MTRP. I found that true and held it in abeyance for the defendant to continue working on probation. Number 4, allegation in this motion to revoke probation, second amended motion to revoke probation, states that you failed to provide verification of entering and successfully completing the anger management program as directed by the probation office. Is that true or untrue?
It's technically true. However, I did seek that program out. I actually sought 2 programs out at 2 different locations. The first one, the instructor did not show up at all. On the second time that I tried to seek out an anger management program, I was told that they were full. And so at that point.
Ah, yes. The classic, technically true defense. Lawyers everywhere are shaking their heads. In court, technically usually translates to, I didn't do what I was supposed to. But let me tell you a story. Spoiler, judges prefer paperwork over excuses.
I let her know that it was court ordered. I spoke with Jennifer with Family Services. And I let her know that it was court ordered and that I was needed to take that class. So what I was done was put on a caseload by the caseworker is who I was assigned. I was assigned by Jennifer to a caseworker named Tatarisha is her name. And so from then on, I was on the list for the anger management class that I was supposed to take. So I should still be on the list for that because other court appointed, other court, I just said the word, there were lots of other people that were on the list that were court ordered, to take different classes as well as that one. So that's why there was a list.
Okay, well, from probation's standpoint, and again, everybody raise your right hand. You solemnly swear or affirm any statements you're making during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
You did, and defend. Okay. How do you respond on this one? It's because it sounds like she's working the anger management program on her own, but I know that's working through a supervision method from probation.
They send over like emails stating that they have signed up for the class and this is the date that it's supposed to start on. But also I gave her an option through Faith Tabernacles in Port Arthur. It is a free anger management classes that they offer. And if you don't have transportation, they do provide it.
And you gave her that back when?
It was
What
May
about,
28th of
what about that?
November.
I do not recall being given that. However, I was given something else, a different printout regarding regarding finishing the what are those hours? Community service hours
Community service.
is what I was given a printout of. Basically,
Hold on, just a second.
so when
Hold
I
on.
went there,
Stand by,
okay.
stand by. Finish up, go ahead.
Okay, so when I went to community service, that I was given a paper, stating what I was to do, who I was to meet with, which was Rose Payton. I was denied that, but that's the only thing that I can recall, that I was given something in writing to actually go and see about this. I do not recall being given any information regarding the anger management class. However, I do remember being given a pamphlet of some sort. However, I had already mentioned that I had already knew of a place that was doing the anger management class. So I didn't think that I was going to have an issue with basically being able to take the class. I didn't think it would take but a few weeks to complete that, is what I thought. However, it's been years and I'm still on that wait list, is what I'm assuming. However, I do have ability to pay for the class now. However, at that time, I was in a homeless situation, but I was looking for a suitable home and things like that. And I had gotten stolen from, is what had happened. I was my check had been stolen, so that was why I was having issues with the payment for the class. However, I was working, but that job
Major
is
point on that one. On
Okay.
6, this number 6 states you failed to report the probation office on or about September 14th of 2024. That's the last problem here.
That was for the judicial review. She was supposed to be here.
She's supposed to be here. And then what happened? She failed to be here.
Right. I believe she spoke with Miss Ellie, stating that she would be unavailable. Last time we had came, that's what she stated.
Okay.
She also testified, I believe, that she thought the charges were dropped or something of that nature, even though they weren't. She thought they were.
Right.
She didn't need to come. I believe it was.
Wait. Just because she thought that, who told her that?
someone at the court.
Who?
At Judge Stevens' court. I don't know. I guess your clerk.
Do you have a name?
I spoke with. No.
Well, I mean,
There was 3 different clerks that I had actually spoken to.
Who told you to report here in the first place? To report to the probation office? It was to the probation.
This is where the legal train starts skidding off the tracks. In probation world, verbal assurances from a lady at the clerk's office do not override. Official court orders, if it's not in writing and signed by the judge, it's as real as Monopoly money.
Probation office for a judicial review.
Well, the last time that we were in court, in I think 2023, I was in court
on September 14th, 2024.
Huh? Well, what I was getting at is, a while ago I was in court with, like in this court with Judge Stevens, and what I was told was that you wanted to see me back in 6 months. However, I wasn't given anything in writing, so maybe that's the judicial review that she's talked about that I was supposed to be here for. However, once those charges were said to me last year to be dropped around August of last year, I assumed, it could have been like June or so. I assumed that meant that I no longer needed to check in, and I did call her, but she was unavailable. So I left several messages.
Call who?
My officer Mayfield.
Okay.
What's
your response to all
is
that?
who I contacted, and I did leave voicemails, but I never received a call back.
We had a judicial review set. It was actually back in May, I want to say, because this took place originally in December. And then after that, it was reset, and then it wound up being reset again, and then we were supposed to come for on the 14th of September.
Of last year.
Correct.
And then that didn't happen. Was otherwise, was she reporting properly?
No,
Oh, she had absconded?
she wasn't absconded until August 30th of 24. She last reported to the office May 28th of 24. And that's when she had said, whenever I would speak with her, she told me that she was informed that her case was dismissed. And I was explaining to her that that's not the way it works. We don't have documentation, and it's only Judge Stevens that signs off on that.
Okay, so what period of time did she fail to report? No, she had already, we had already found earlier failing to report in June, August, and September of 23.
Correct.
After that,
It was June 27th of 24, July 18th of 24, July 30th of 24, and then July 31st. She was also scheduled on August 22nd, but that was the day that she was arrested on. Since that, 24.
okay. And you knew you had to report every month, right?
Prior to me being,
You knew you had to report every month, right?
that my charges were dropped. Yes.
Who told you your charges were dropped?
There was a lady that I spoke with, one of your clerks. I contacted them and told them what my name was and asked them to look up the pause number. And I told them I was representing myself at that time. They looked it up and said that we showed that there are no charges under your name, is what she said.
Right.
So what I did was I let Officer Mayfield know that is what I was told. However, I didn't speak with her. I left it on her voicemail several times so that she would know. So at that point, she should have known that I was not purposely trying to avoid checking in, because I didn't have a problem checking in. I was always early.
Wrong. You were absolutely wrong. You were absolutely wrong. And you have no name of anybody some vague anonymous person, you say,
It's
from my
true,
court. Are you going to interrupt all day? That's the problem, has always been that you want to control things. It's on your terms. You're the boss of your environment. You're on probation. You're supposed to be the probationer, and I'm supposed to be.
That's the judicial equivalent of a basketball ref blowing the whistle, waving their arms, and calling a foul. Once the judge moves from questioning to flat out declaring, "You absolutely wrong. Your chances of walking out without consequences just took a nosedive."
The supervising person, and she is too, but that's not the way you work. You want to control, and you keep interrupting. I would be called down in second grade for that. We learned in elementary school not to interrupt. That's rude, but that's what you do. All right. Anything else, David?
I'm not trying to interrupt.
Anything else?
No,
Okay.
nothing else, Judge.
I find there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation to grant it by a preponderance of the evidence or greater, as allegation 6, failing to report to the probation office on or about September 14th, 2024 for this judicial review, has been proven not only by the court's knowledge, but also from probation, the probation officer. And again, introduce yourself for the record.
Dominique Mayfield.
Yes, Miss Mayfield. And how long have you been her probation officer? Working her case?
It was February 14th of 2024.
Okay. So it's been a year and a half anyway.
Yes, sir.
Mm-hmm. And she was supposed to be reporting
Correct.
monthly. And during your period of time, when did she fail to report? During that period of time, from early 24 until now?
It was June 27th of 24.
Is what? Was
Sorry.
what?
It's an answer to your question, Judge, about dates she didn't report.
Okay. So she failed to report the month of June.
Yes, the month of July and the month of August of
August.
24.
And then we had this judicial review in September.
Correct.
Okay. What, after that, when was she arrested and put in custody?
She was arrested December 14th of 24 for this first
Okay.
week.
And have you been in custody that whole time?
No.
No, you were released.
Was,
Because I have 631 days that you've served.
Well, no, what I was going to say is I was picked up prior to that date. It was 2 dates in December that I was picked up.
Or
They said I was walking on the incorrect side of
Oh,
the sidewalk or something like
okay.
that is what they said. But it was within 1 week of each other that I was picked up, and I had bailed out within like a day or so. And then I was out for 1 week, and then I was picked up on December the 18th or something like that.
all right.
So her dates is probably correct.
Okay,
But-
here's, anybody else wants to add anything?
No.
Here,
Judge is right, though. You've been in
I've been in-
for 600 days.
yeah, 631 days.
Been in custody since the second time I
Oh,
was
well, we're gonna
arrested.
Take care of this.
So Judge, I've got that you have found count 6 true. You want to make any other
Yes.
findings?
No. Well, earlier, we had found true in 2023. That was in the 1 through 5.
Yes, sir.
But 6 is what I'm
Yes, sir.
more concerned about is after that hearing we had last time, I continued her on probation. And then the evidence shows that she had failed to report on several occasions here since in 23 and 24 as she was supposed to, which puts it into a impossibility of being able to supervise you when you don't show up for work, as it were. So I'm going to find that to be true, and just I can't just say enough. This is about the 5th time I'm going to tell you, please don't interrupt. You're going to get a chance to be heard. All right, what does the state say?
State recommends 5 years, Judge.
Wow, for the first time, I've never been in trouble before at all.
All right, hold on.
It's interesting.
What do you have to say, David? And then I'll ask the defendant.
Your Honor, because she has been involved this long and has been to court this many times, I'd ask that the court show her some mercy and discharge her because she's been in.
And there it is. The prosecution swings for the fences. 5 years. This is a high-stakes moment. Will the judge go for maximum punishment, or will the defense's plea for mercy land? Stay tuned, because this could flip either way.
Custody for most of her term.
Okay, I understand. Anything you want to say, ma'am?
Yes, I would like to say I'm a very responsible person. I'm clergy. I'm also an officer of the court. I'm a new election judge for Jefferson County.
Say that again.
I'm a new election judge for Jefferson County. And so,
But you have a felony conviction, right?
well, here's the thing.
She
There was
was-
trafficking involved inside of Jefferson County Jail that I reported to the Rangers years prior. And so that's really not a safe place for me. However, everyone is now mild-mannered years later. And I had a special needs child that I do still have, but I was needing to get back to him because he was in a hostage situation with a predator who was an ex-fiance of mine. So it was a pretty serious thing that was going on years ago.
All right.
And so I was trying to get out the best way that I could to attend to him and his needs
Okay.
in
Well, you're gonna-
2022. I was put in 2021, and I did a year and 2 months. And then I was released February of 2023. And then I was picked up again September of 23. and stayed until the new year of 24.
Okay, got
And
it.
then I was,
Well, we've got all that covered
Okay.
here. I'm going to find that there is sufficient evidence supporting the second amended motion to revoke unadjudicated to grant it by preponderance of the evidence or greater, as allegation 6 is proven true, as well as prior to this, the court found allegation 1 on December 18th, 2023, failing to report as well, for which we continued the defendant on probation for. But those two bases are behind this court granting the second amended motion to revoke unadjudicated probation. Thus, your deferred or unadjudicated probation is revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here at your plea hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony of assault on a public servant. And you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, the very minimum. You're going to be given credit for all time you have served, which ought to satisfy this sentence when they calculate it, and you should be released.
okay.
Okay. Anything else to add here?
No, Your Honor.
All right. Thank you. We are in recess. Thank you, David. Good luck, man. To you.
For all your time served.
The verdict is in 2 years, minimum term, with credit for time served. In practical terms, that means she could be walking free soon. But here's the kicker. Probation was meant to be the second chance. When you miss the check-ins, skip the programs, and interrupt the judge, that second chance evaporates fast.